We're going to spend a lot of time talking about the United States Supreme Court case of United States versus Rahimi. There's a lot to talk about. I'm going to break it down into digestible approaches. To begin with, I want to talk about what the people, as in the right of the people to keep and bear arms, means. How to discuss who might be excluded from it for the purposes of their right to keep and bear arms. Stay tuned. We're going to get geeky in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. I appreciate all of you who have bought it and have listed reviews on Amazon. Thank you for that. I really do appreciate that. And of course, don't forget to follow me on Twitter for more Second Amendment information at 4Boxes. Check that out. Again, I joined Twitter mostly to get more Second Amendment information out there. Wasn't my favorite thing to do, but I did it, and I'm now there. So feel free to follow me on Twitter in addition to this channel. All right, folks. So we know the United States Supreme Court has granted certiorari and is going to hear the United States versus Rahimi case. We're going to spend a lot of time talking about this case. It's very complicated in many respects. Don't worry, we're going to walk your way through it, and I think we're going to find a way to win that case. But I want to start in bits and pieces here. So the first thing I want to talk about really, and this is not just for Rahimi, this is involving how to understand who exactly are the people, as in the Second Amendment's the right of the people to keep and bear arms shall not be infringed. Now, it seems like an easy question, but I want to be very precise. This is very important for our rights, and I want to make sure that you understand how to analyze this question as a professional, not as an anti-gunner trying to take away our rights, but as someone that understands the Constitution and the Second Amendment. I'm going to break it down for you, make it easy to understand so you can be the smartest person in the room. That's my goal to begin with. We start, how do we do it? Well, Heller and Bruen both say when you're interpreting a constitutional right, including but not limited to the Second Amendment, you start with the text of the Constitution. In this case, the text, of course, is the operative language of the Second Amendment, which is the right of the people to keep and bear arms shall not be infringed. Well, each of those terms has been defined by the U.S. Supreme Court in the Heller case. So as you know in Bruen, the first step is you read the text of the Second Amendment as it's defined by the U.S. Supreme Court in Heller, and any sort of necessary implications from there. And that's what you do. So here, I want to talk about who are the people. So how did the Supreme Court define who are the people as a textual matter? And the reason why the textual matter is important is because, as you know, once a modern-day gun control law implicates or touches fingers with the text of the Second Amendment as articulated and defined by the U.S. Supreme Court, the burden shifts to the government to justify, through using historical analogs, if any exists, to justify the existence of that modern-day gun control law. The burden shifts to the government. If the government cannot satisfy its burden, it loses. And as you know, the Mark Smith rule, which is my rule, when in doubt, you throw it out. If there's any doubt about whether or not the government has satisfied that burden, you have to throw out the modern-day gun control law. Okay, so to step back. Step one of this process is you look at the text. Now, the anti-gunners want to argue that the word the people, as in the right of the people, has been edited or modified as a textual matter by adding words like the virtuous people, the law-abiding people, the well-behaved people, the people that we, the anti-gun community, want to define as part of the people. Because the anti-gun movement wants to rewrite the text of the Second Amendment in all sorts of ways. And one of those ways, of course, is to narrow the scope of the people, as in the right of the people to keep and bear arms, to narrow the number of people who can have arms, for obvious reasons. But can they do that as a textual matter? The answer is no, they cannot. Now, I'm going to give you the easiest answer. There's two easy answers. First of all, the Supreme Court has already said that what the anti-gunners want to do with the textual definition of the people at the Second Amendment level, they cannot do it, And number two, I'm going to give you a second killer argument that you can take home with you today. The first thing is, what has the Supreme Court said? You see, the Supreme Court in Heller explained that the words "the people" in the Second Amendment refers, quote, unambiguously refers to all members of the political community and not just some subset. You see what I just said? All members of the political community. The Supreme Court also said in Heller that the people, as in the Second Amendment, refer to a class of persons who are part of a national community or who have otherwise developed sufficient connections with this country, the United States, to be considered part of the community. In the Heller case cited to some other Supreme Court precedent. So, obviously, everyone that's connected, at a minimum, all American citizens are part of the people in the Second Amendment. Now, we have further evidence of this because the phrase "the people" appears in multiple other places in the U.S. Constitution. I'm going to just give you one example here. If you look at the other part of the Bill of Rights, the Fourth Amendment, the phrase "the right of the people" appears in the Fourth Amendment. Let me read you that language. Quote, "the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." That's the Fourth Amendment of the U.S. Constitution. It was ratified and went into effect in the year of our Lord, 1791, the exact same time as the rest of the Bill of Rights, including but not limited to, of course, the Second Amendment. Again, the Second Amendment says the right of the people to keep their arms shall not be infringed. The Fourth Amendment in the Bill of Rights says the right of the people to be secure in their persons, houses, papers, and effects. Do you see how? Obviously, the people in the Second Amendment and the Fourth Amendment have to refer to the same group of people, and the Supreme Court has repeatedly said that the people in the Bill of Rights refers to basically all Americans. That's what we're talking about here. Okay, so at a textual level, any American citizen who has their right to keep and bear arms infringed upon or restricted by modern-day gun control law has a Second Amendment claim. Okay? So now what? This is very important. In the Rahimi case, for example, Mr. Rahimi, whether he's a good guy or bad guy, criminal or not criminal, that's not the issue with this discussion. At the textual level of this analysis, he clearly falls within the set of people known as the people who have a right to keep and bear arms. Just like he falls within the Fourth Amendment's the right of the people to be secure in their persons, houses, papers, and effects. He's part of the people as a textual matter. Now, the reason why this is so important is that means that to the extent the gun control law being litigated in the Rahimi case, which is the restraining order provision of 922G8 under the Federal Criminal Code, if you're subject to a particular domestic violence restraining order as defined by that statute, you're not allowed to have a gun, which clearly impacts your ability to have the right to keep and bear arms. So the question in the Rahimi case is that constitutional? We'll get to that down the road in future videos. But at a textual level, Mr. Rahimi is obviously part of the people. Now, this is important because once he's part of the people, as defined by the text of the Second Amendment, and the modern-day gun control law, which 922G obviously does touch fingers with the right to keep and bear arms because it prohibits people from having guns, so it implicates the Second Amendment. The burden now shifts. This is the key. The burden now shifts to the United States government in the Rahimi case to somehow use history to show that Mr. Rahimi or someone like Mr. Rahimi can be disarmed. So even though Mr. Rahimi textually is part of the people, and the modern-day gun control law implicates the Second Amendment, the burden shifts to the government to say that 922G8, the bill dealing with domestic restraining orders, that somehow can be justified as a matter of history. But as we've talked about, when the burden shifts to the government, in the same way like if you're charged with a crime, the burden is on the government to prove that you are guilty of that crime beyond a reasonable doubt. And if they fail to do that for any reason whatsoever, the government loses and you go free. You don't have to do anything. The government has the whole burden. Likewise, in the context of the Second Amendment case, once the text is satisfied, and here Mr. Rahimi is part of the people, and his rights are impacted, which they are because he's not allowed to have guns under the current federal statute, the burden is just to the government to come forth with a historical justification. But remember, we've talked about the meaning of history here. It's not just any history. They can't just get a historian to tell stories about American life, the history of the revolutions. We are musing about the meaning of history. No, none of that. The Supreme Court has been very clear that the type of history that counts, that the government bears the burden to come forth with, is a very specific type of history. Specifically, the government has to show that the regulation they're trying to uphold in 21st century America is consistent with or part of the long-standing historical tradition of firearms regulation as demonstrated by actual regulations, actual laws that were on the books at the time of the founding that were not only on the books, but were actually enforced. Again, the anti-gunners want to bring forth historians from Ivy League schools just to tell stories about why they can take away guns. But the Supreme Court's not interested in that. The Supreme Court wants historical laws that regulated guns in the same way, the time of our founding, that they do today. If that connection does not exist, if those relevant analogs don't exist, the modern day gun control law is supposed to fall under the Bruen methodology, which really, as you know, the Bruen methodology is really the Heller methodology that the lower courts couldn't apply correctly, and Bruen laid out the Heller methodology in paint by numbers, sippy cup fashion, so lower courts could follow the Heller methodology of text first, historical analogs second. Bruen is basically Heller repackaged so that lower courts can understand the process easier because they weren't getting the Heller methodology correct. So now when you hear about Bruen methodology, as you know, it's really just the Heller methodology laid out for lower courts in a much more elaborate, clear way so they can't screw it up, which had been going on for over 10 years between Heller and Bruen. Okay, now to go back to the question of Mr. Rahimi and the question presented, is he part of the people? At a textual level, Mr. Rahimi and everyone watching this who's an American citizen, and likely those of you with green cards, for example, or here in the United States legally, you're all part of the people for the purposes of the Second Amendment and the 14th Amendment. This is a general idea, okay? But then the question is, can Mr. Rahimi or someone in Mr. Rahimi's position be disarmed? Well, he can't be disarmed at a textual level, so then the only way he can be disarmed, of course, is you have to look at the history, specifically those historical analog laws. So the question is, are there historical analog laws that allow certain Americans to be disarmed or lose their gun rights in some way that the text doesn't specifically speak to? Now, to keep things simple, and remember, I'm trying to give you an overview here because there's going to be a lot of super geeky stuff coming down the pike. And I want to kind of give you stuff slowly but surely to build up this base of knowledge. And every little thing I give you is going to be extremely important for you to understand, not just for you to understand it because we want you to be the smartest person in the room, but to make sure that the courts and other people analyze this correctly. Because if they get it wrong, it's going to hurt all of our rights. We're going to lose our rights in one form or another if they screw this up. That's why I talk to you about this super inside baseball stuff. Okay, so now, we've already talked about the text. Rahimi's within the text. We're all within the text if you're an American citizen. The burden shifts to the government. They have to show actual laws. For the purposes of the video, I think there's two categories of Americans that I think can be, quote unquote, disarmed. One is a little fuzzier, one's a little clearer, okay? Now, maybe there's other categories and you'll let me know. But as I see it, for our purposes, as a basis of historical laws on the book on the books at the time of the founding, I think there's two categories of Americans who are the people that can be disarmed or have their rights taken away in some way when it comes to firearms. The first category is not that controversial, and that is, I think that American citizens who are under the age of 18 arguably can have their guns taken away by the government or be denied the ability to use firearms. You see, at the time of the founding, if you remember, 1791, the Second Amendment is adopted. 1792, the Militia Act of 1792 is adopted, saying that all Americans, all American whites, white males, able-bodied white males between the ages of 18 and like 45, they are all part of the militia, and they have certain obligations, including but not limited to bring their own firearms and ammunition and powder with them to militia musters. If you then look at the history after 1792, where the states had their own state militias. Remember, the Militia Act of 1792 is the federal militia, but you had state militias as well. You start to see in the late 18th century the notion that 18 is when really militia service begins, that the states coalesce around the idea that 18 years of age is really the age of majority for the purposes of militia duty. So in light of that, I don't see any way, as I see it, that 18-year-olds and above who are American citizens can be denied the right to keep and bear arms. But I do think that if you're under the age of 18, then the parents get to determine whether or not you have access to firearms. The government does not, but the government can say that you don't have access to firearms because, again, I think at the time of the founding, if you look at the laws on the books and whatnot, 18 is really you become a full-blown American for the purposes of the right to keep and bear arms, and therefore I think under the age of 18, you don't have the same level of rights, and I think you can be subject to greater restrictions and bans and whatnot up until the time you turn 18. Then you're an adult, and it's a different world. Now you're a full-blown citizen for the Second Amendment, and you get to have your guns and all that. But under the age of 18, I think historically there can be regulations. Doesn't mean the government has to do it, but I think they probably could do it consistent with the history of the Second Amendment and who was protected and what people understood to be adults at the time of the founding. So the one category I think that can have their gun rights restricted are American citizens under the age of 18. The second category is really going to speak to, I think, where the Rahimi case and maybe the Range case out of the Third Circuit dealing with nonviolent felons may ultimately go to. And that is the second category of, and this is where the fight's going to take place, the pro-Second Amendment community says that if you are a violent danger to society, either because you're a violent criminal or you're a psychopath, mentally ill person that's a danger to yourself or a danger to others, you can be disarmed. Specifically, the touchstone is danger. If you're a danger to yourself or a danger to others, then I think that's a second category. The first category being under 18. I think the second category is, at the time of the founding, there's ample evidence that people that were viewed to be dangerous to a society could be disarmed. Now, I want to remind you that the anti-gunners do not like the dangerousness standard. They are arguing for the standard of virtuous. They want to say that anyone who is not law-abiding, as they define it, anyone who is not virtuous, as the anti-gunners define it, they get to lose. You get to lose your gun rights. They get to take your gun rights away. Now, this is a very dangerous thing because there's no limiting principle to what is virtuous. There's no limiting principle to law abiding because everyone speeds on occasion. Everyone jaywalks on occasion. Everyone goes through, slides through a stop sign without fully coming to a stop on occasion. Everyone maybe screws up the recycling effort. There's all sorts of little things here that people do that are, technically speaking, a violation of the law, which makes one arguably not law-abiding. And if the anti-gunners had their wish, anyone that jaywalks, anyone that doesn't recycle, anyone that doesn't what they say is law-abiding, anyone that speeds can be deprived of their right to keep and bear arms. That is where the anti-gunners want to go. And that is why there's this fight between the pro-gun community that says, yeah, if you're literally a danger, a violent danger to society, we get to put you in prison, we can take away your guns, we can put you in a mental health institution because you're actually a danger. And after a trial and after evidence and all that, it's clear you're a danger. You're Hannibal Lecter, right? You're Jeffrey Dahmer. We can take your gun rights away and lock you up or whatever it is. Of course, the anti-gunners say virtuous or anything that's not purely 100% law-abiding at all times. They want to take away your guns. That's where the rubber hits the road. Be aware of that. Now, it seems pretty clear to me that the right answer should be dangerous. There is enough 1791 founding era history, as, for example, Judge Amy Coney Barrett, before she sat on the Supreme Court, found to exist, that the legislatures at the time could disarm people who have demonstrated a proclivity for violence or whose possession of guns would potentially threaten public safety. There's examples of this, of certain groups that would not swear an oath to the American Revolution, would not swear an oath to their states. That was viewed as a sign that they might be a danger, a risk of becoming insurrectionists or rebels against the American cause. And these were all viewed as a danger to the society. We also know that Judge Bibas out of the Third Circuit has written specifically in England and in colonial America, the government disarmed people who posed a danger to others. Violence was one ground for fearing danger, as were disloyalty and rebellion. Again, at the time of the founding era, there is clearly evidence that dangerous people to the society could be disarmed. Some of that included the Quakers. Some of that included Americans that really were Tories, wanted to support the British cause. Again, there's a whole list of these things. And again, we don't need to get into all the details here, but that is where I think the Supreme Court will ultimately agree that the touchstone for taking away someone's gun rights is that they are dangerous or, again, under the age of 18, which, again, is not an issue being litigated right now. Okay, so I hope you learned a little bit something here today. I took my time. I want to break this stuff down really clearly for you so you can take detailed notes and get this analysis right. But again, it's text. All Americans fall within the people, including even 1-year-olds. But then the burden shifts to the government, and the government will be able to show, in my view, that you can't take guns away from people that are actually dangerous, and you could, in theory, take guns away from people that are under the age of 18 if the government wanted to disarm or do that, because they haven't quite reached the age of 18, which is really the age of majority for the Second Amendment purposes if you look at the history. But again, the burden is always on the government to show through history that a modern-day gun control law is consistent with a long-standing tradition of firearms regulation, which requires identifying not airy-fairy history, but specific actual laws on the books at the time of the founding that were actually enforced. That's the burden of the government. But I do think the government can ultimately show that people under 18 and also those who are actually dangerous can potentially be disarmed in modern-day America. But again, we'll talk a lot more about this in the future. A lot of these things are going to pop up at the Rahimi case, and that's why I'm trying to do this building block approach so that you get all the basics right, and then you'll be able to analyze the Rahimi case for yourself, and then we'll see what the Supreme Court does this fall when they hear oral arguments. In the meantime, if you haven't subscribed to the 4 Boxes Diner, please do so. Make sure you follow us on Twitter at 4 Boxes Diner. And again, we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.